A motion to call the meeting to order. Motions was made by Brad and seconded by Kurt Shervin. All those in favor say aye.
Aye.
Opposed, motion is carried. Would look for hopefully everybody had a chance to look through their packets. Would look for a motion for approval of the agenda with some flexibility tonight.
I'll make a motion to approve the agenda.
Motion is made by Ezra, seconded by Dave to approve the agenda with flexibility. All those in favor say aye.
Aye.
Opposed, motion is carried. Hopefully, everyone has had a chance to look at the minutes from last month's meeting. Anybody have any corrections or adjustments? Hearing none, look for a motion to approve.
So moved.
Second.
Motion by Sebastian, seconded by Ashley. All those in favor say aye.
Aye.
Opposed, motion is carried. Is there anyone in the audience that wishes to speak on something that is not on the agenda? Is there anyone in the audience that wishes to speak on something that is not on the agenda? Anybody online?
No, Mr. Chair.
Third and final, anyone in the audience that wishes to speak on the agenda? Hearing none, we're going to move to the public hearings, and we are going to skip over the request for an IUP and go to the land development ordinance update. And then there was substantial paperwork in everybody's packets. Hopefully, everybody had a chance to look at the notes. Take it away, Matt.
No.
We need the public hearing open,
Okay,
please.
look for a motion to open the public hearing.
I'll make a motion to open public hearing.
Motion by Ezra,
Second.
second by Ashley to open the public hearing. All those in favor say aye.
Aye.
Opposed? Public hearing to discuss the Clay County Land Development and Subdivision Ordinance Code. is
Right.
open.
Thank you, Mr. Chair. So Clay County is in the process of updating the land development and subdivision ordinance. This ordinance regulates land use in the unincorporated areas of Clay County in accordance with the 2045 Clay County Comprehensive and Transportation Plan. The Planning Commission will consider recommending ordinance adoption of the Clay County Board of Commissioners. Draft ordinance is available for review online. Comments and questions can also be submitted by calling the planning office or by email at planning@claycountymn.gov. So, with that, I know that in the time period between when this notice went out and now, we did get our comments back from attorney who reviewed the subdivision regulations chapter and then the administration and procedures chapter of the ordinance. So what I want to do tonight, essentially, or what I'm proposing, is that just to kind of give you an overall update on where things are, and then look for any comments from you all just on the ordinance in general, if you've had a chance to kind of review some of the other chapters, just an opportunity for that. And then just some discussion on those two chapters, mainly focusing on the administration and procedures chapters, because there are some pretty substantial comments in there that I would say differ from how our current code looks and how this planning commission has operated in the past. So with that, I'll just jump right into it. So where we're at with the update, we're essentially complete with, I mean, as I've said last month, we have basically a full, and probably been saying this since January, a full draft ready to go. Just getting some additional comments from other entities that are requirements. The first being our shoreland section. The DNR has reviewed that because what we're doing is essentially realigning our current shoreland ordinance to better match the state shoreland rules. They don't really have too many comments. They just have some minor revisions. I think the main comment that they had was just we're missing some definitions that they would like to see in there. So those should be pretty easy changes. How that process works is before our April meeting, the DNR will send us a conditional letter of approval with any suggested changes. We make those changes, and then they would essentially approve the shoreland portion of the ordinance. In state statute, there is something that requires the Pollution Control Agency and the Department of Agriculture to review our feedlot section. There's some other requirements in there as well. MPCA, I had reached out to them a couple times. Finally, I think got to the right person, and they said, nope, that's not required. Don't have to do that. If you want, we can review it and just give us some comments. So I said, sure. So that's what they're going to do. Subdivision regulations. So the comments that we received from the attorney on the subdivision regulations, I think for the most part, unless any of you want to talk specifically about any comments, I feel pretty comfortable with the comments that were made. I don't think that they're require any major changes to what we have. Just some tweaks here and there. So unless anyone has anything that they want to point out specifically, I know Mr. Steichen, you had mentioned something. I don't know if that's something you want to bring up to the group at all, or sure.
Yeah, obviously the attorney has done a very thorough job of reviewing it all, because there's certain things that she found that, to the average person probably wouldn't even understand the difference. But I guess on her page, on the page 2 of her comments, number 1, let's see, am I reading it right here? Page 3, number 1, that's what I meant. The development agreement discussed in section 8.6-13.b.
Yeah, I have it up too.
Do I have it right there, Matt? It talks about a reference to something that's mentioned quite a ways back. And Matt, you could probably explain what I was talking to you about better than I can, but to me, it seems kind of important to have that in there, because obviously it's probably duplication, but when you're dealing with that particular part of it, it does reference, I just had,
Mr. Chair, I think you're talking about the pre-application meeting requirement.
Yeah.
Yeah, and so we have that essentially duplicated in a couple spots. So we have a whole section right at the beginning on page 3 dedicated to that. And then it's just mentioned again. So we have an administrative subdivision process and then a major subdivision process. And it's just mentioned as a step, I think, in each of those as well. And it refers back to that section. And she
Doesn't
just
change the fact about any of the verbiage, just duplicates. I mean, if you're actually looking at that, it seems like it has a good reference. Yeah, it's probably duplication, and it doesn't really matter too much. I like those things when they are duplicated.
Yeah, just to make sure that, I think she thought we could strike it just because it's duplicative of this section. I'm kind of the opinion, same as Mr. Steichen, to just keep it in there, just because it's, when you're going through the subdivision process, it's you almost have to view it as like a checklist of things that you need to do and steps that you need to make. And it's pretty easy to miss a step. So if we can keep it in there, I think it would make sense, depending on what a developer or an applicant is doing. If they're doing an administrative subdivision where they're just splitting one parcel into 2, or if they're doing a whole major development.
Other than that, I mean, it all obviously has been reviewed quite well, and a lot of work has gone into it by both Mr. Jacobson and the attorney, so other than that, I thought it was good.
And Mr. Chair, I think one of the main things that I was maybe thinking she would comment on was the section 8-6-5, township approval required. She didn't really have a whole lot to say about that, just because there is a state statute whenever you're platting and laying new roads that are in a township, and the township has a planning commission, then township approval is required. And in the interest of basically, because sometimes townships have a planning commission, some don't, just making it a blanket requirement. It's something that's required in our current code for roads. But that is because that's in statute, just making sure that if a developer's coming with a proposed subdivision that requires new roads, that they first go to the township before coming to the county and get that approval. Just because ultimately it would avoid the maybe premature investment of a lot of time and resources into doing the platting process and the surveying and all that, coming to the county and then find out, oh, no, the township's going to strike it down anyway. So unless anyone has anything else about the subdivision chapter, I think we can move on. It's personally, it's my least favorite chapter of the whole code. If I had to pick a favorite and a least favorite. All right. Just want to give you an update as well, just on chapter 4. Just had some conversations. I think Kurt and Commissioner Bear were involved with this, just adding a new use to our use table and to our use regulations for temporary agricultural worker housing. It's something that other counties in the state are seeing more of. A lot of counties in the state do allow this, and they do have regulations for it. So just kind of thinking ahead, putting that in there as a use, and including those standards as well. I think the main in the southern part of Minnesota, you see a lot of the H-2A visas. And then up here, I know there's been some conversations with sugar beet producers about finding truck drivers and things like that, and to haul beets. So the other thing that will likely change maybe a little bit is the cannabis section. I don't expect this to change a lot, but I just want to compare it to the model ordinance that the state put out and updates to that model ordinance, and make sure that we're at least in line with that. The cannabis regulations are kind of a moving target, just because it's legal. They've had a licensing period for it, which closed on Friday of last week, and there aren't any rules yet. So kind of doing things a little backwards, but I just want to, I'm always kind of keeping this kind of on the front end, just in case something changes, especially with the rules, just so we're as most current as possible and making sure that we're in compliance with the state rules.
I see Becker County.
You have your mic on by chance?
Yeah, it's on.
Okay.
Sorry.
No worries.
I did see Becker County approved a cannabis facility.
Yep.
Becker County here, I don't know if that's something that we could, talk to them about, or see what rules they've adopted, anything other than just the, because it seems like it's a legit operation going, and it's coming.
Yeah.
It's gonna be here before you know it.
Yep. Yeah, and I think we've received some inquiries about cultivation and also retail outside of incorporated cities, so in unincorporated areas of the county. Yep, not many, but what it sounds like is folks are waiting to see if they are getting their applications in for a licensing and see if they even have a chance of getting a license before going through that process. But not the case, I guess, in Becker County. So for that business in Becker County, they would still need to get that licensing. So they just kind of took the zoning, county permitting, did that first, I think, so.
Matt, if I remember correctly, can that only be done on highway or limited highway?
Yes. Yep. So the way our ordinance is right now, that we are considering cultivation, manufacture, wholesale, retail, all commercial or industrial uses. And so they would be limited to our highway commercial or limited highway commercial zoning districts at this time. All right, unless anyone has does anyone have any questions or comments about, chapters 1 through 5 at all? The only potential other thing that I did not include in my PowerPoint here tonight is that last week, the Buffalo Red River Watershed District reached out. They're looking at potentially developing rules for setbacks from public ditches, from drainage ditches that are under their jurisdiction. I think the example they gave especially is with solar development, but then other types of development as well. And I don't know what that would be. Other watershed districts or judicial authorities, ditch authorities, will measure from like the center of the ditch, and it ranges anywhere from 50 feet to 200 feet. They're looking at doing it from the ditch right of way essentially, but they just don't have a number yet. So that's likely, I would advise against coming up with their own setback that differs from whatever rule that they're going to make. But so that whenever they come out with that, that might be something that we might want to consider coming back and amending the ordinance so we're in line with them, if that makes sense. Yep, once they figure out, all I know is that they want it, it's going to be from the right of way. I don't know if it's going to be 25 feet, 50 feet, 200 feet. I don't know what they're, yep. So. Exactly. It's the moment it's approved, it becomes out of date, basically. Yep, exactly. Just like an encyclopedia or a map or, yep. So it's a living document. All right, if no one has any comments about chapters 1 through 5, I'm going to take that as a good thing and that you all are satisfied with what's in there. That is kind of the bulk of this. And we can just dive right into chapter 7, administration procedures. I'm going to keep things pretty high level, and for the most part, there are some areas where we might want to have a little bit more discussion. But the kind of 4 things that I want to just touch on are procedural consistency, the review criteria for use permits, amendments, and variances, the appeals process, and then violations, penalties, and enforcement. And then anything else that you might want to discuss as well. So overall, I think one of the big themes in the comments that we received was just making sure that we're procedurally consistent between the county board, the Board of Adjustment, and the Planning Commission, that the powers and duties of each of the boards are consistent in their description and roles. There's some in terms of how they handle applications, what they're describing the makeup of a board, how a planning commission is appointed, and things like that. And then our amendments, use permits, and various variance applications and procedures, just making sure that those are all consistent as well. And then our notice requirements, that they align with state law. We largely left them in our draft as they were in the current code. A lot of what we have is way more stringent than what is required by state law. And so in the interest of aligning more with state law, that's kind of the thought there is for noticing requirements. Typically for any type of county or governmental decision, you have essentially 60 days, so the 60-day rule to make a decision. And it's, in some of our cases, we have gone down to 30 or 10 or whatever, for whatever reason. You can extend that an additional 60 days. You can extend it even longer if the applicant or the person awaiting that government decision agrees to it in writing. So just kind of aligning everything more with the 60-day rule, just to keep that consistent. We did spend some time with the at the Board of Adjustment meeting this evening, just talking about review criteria. So these are when you're looking at like a conditional use permit or an interim use permit, when we go through our findings of fact, you're going through these review criteria. For variances, the Board of Adjustment does the same thing. Because you are not the Board of Adjustment, I'll not spend a lot of time on it. Just want you to know that we're looking at streamlining these a little bit more, kind of cutting down the review criteria just to match with what's in state statute. Because the review criteria for variances is actually in state statute. For use permits, that is not in state statute. So really, we could have whatever use criteria we want. And right now, we have 13 criteria. I think Ezra and Joel have both lost their voices, and past chairs lost their voices reading through those. And maybe some of you have nodded off a little bit when we get down to like 10 or 11 on there of the review criteria. So what I'm proposing is that we trim that down to 7. And so these are the first 4. No, but I can send this out. Yep. Yeah. So really just, I think the issue with the current review criteria that we're using is like the first one basically covers everything in it. And then there's some repetition that happens. And so it's not very clear. And so trying to make each of these criteria distinct, I think is really important, just because then we can always just focus on that one and not get all jumbled up with. The first one is on our current is, I think, too long in my opinion. So then these would be the 5, 6, and 7.
That's for conditional use permits, right?
Conditional and interim use
Okay, I
permits.
didn't know.
Yep. Yeah, the review standards for interim use permits would be the same.
You just substitute the.
Yep.
Okay, gotcha.
Yep.
I like it.
Yeah, and I think one thing that this will do is just generate more focused discussion as well. I think it can be overwhelming to have 13 review criteria and maybe a little bit excessive. And if we can just hone in our discussion on whatever permit is before the commission at that time, I think this will just help hone in a little bit better. Any thoughts, comments, questions? Keep it in alphabetical order.
I think it's a great idea. You everything is still covered, but
It's more concise.
Yeah.
Mr. Chair and Matt, obviously these 13 ones that were on here was, some of them pretty narrowly, describing certain parts of it. If push come to shove and this had to be held up in court, is these 7 going to cover it equally well as the 13, in your opinion?
I would think so. Some counties have 4,
Oh, well,
5. I mean, yeah. Yeah, in my opinion, I think that would cover it, but that's almost like 4 or 5 different review criteria slammed into one. The only one that I might consider adding that is no longer on there is the first one just being strictly about the health, safety, and general welfare of county residents. And I don't have that on here, and I meant to, and I think maybe that's one that I think we maybe should add, and that should be the first one. The reason being is that with use permits and basically any type of decision that you're making, that's kind of the lens that you should be looking at it through every decision is how does this impact the health, safety, and welfare of the county. So that might be a one that I would add back in there. And just stop it there. And that's in our current one right now, but then it continues to go on and on and on. Okay. Yeah, that's kind of what my thought was too. For text amendments, review criteria, just keeping it to 3. I think we have 4 right now. Again, just trying to make things more succinct and streamlined here. Because really, when we're looking at a text amendment to the ordinance, I think really 3 is probably the big one, is you're looking to make, because the ordinance is the main tool for implementing your comprehensive plan. And so number 3 is kind of the biggest one, is it consistent with with the goals and objectives of the comprehensive plan? Is a nuclear power plant next to a residential subdivision consistent with the goals and objectives of the comprehensive plan? Probably not. That's probably above our level here. A battery plant or a data center, that's one that counties are grappling with right now, is data centers. They're not in our ordinance right now, so they're technically prohibited. But that's a big one. Western North Dakota, southern Minnesota, so. Yeah. And AI stuff, yep, so. And just generally people storing more things online. Yeah. No one has any really good standards developed yet for that, yeah, which makes it tough. For zoning map amendments, trying to keep, so a zoning map amendment, one thing that's important to know about a zoning map amendment is it's essentially the same thing as a text amendment, because the zoning map is adopted by reference in the ordinance, so they're essentially the same thing, but they're a little different in that a zoning map amendment often is focused on a specific property or area. And so looking to keep these the same, but adding a fourth review standard in that the proposed use or zoning district is compatible with the surrounding uses or zoning districts. That's kind of like a check against spot zoning, which is not legal in Minnesota and most everywhere. And I think we might loosen up some language here because I think in our current draft, we have it focused on a specific property. But there can be instances, and this planning commission has made recommendations to the Board of Commissioners before to zone whole entire areas of the county, not just specific to one property before. Same with like if a new zoning district were to be adopted in the future or anything like that. The next thing I want to talk, does anyone have any comments on this? Okay, the next one I want to talk about is just appeals. So kind of laying out for different applications or different decisions, how appeals may be proposing to be work. And I'm still discussing this with Attorney Melton on what we want to do here. I don't know if we have a thought, but their recommendations would be, I think for administrative decisions, if someone were to appeal a building permit denial or something like that, the process is that would go to the Board of Adjustment. And then it could either go to District Court or Court of Appeals. The recommendation is it to go to the Court of Appeals. Variances, excuse me, variances do go to District Court because that's explicit in statute. Use permits, right now how we have use permits set up is, say someone is denied an interim use permit. They can appeal it to the county board, and the county board can make a decision. If the county board denies their appeal, then it would go to either District Court or Court of Appeals. That's how it's currently laid out. I think the issue is that anyone, technically anyone, can appeal a permit decision. So like a neighbor or something like that. So say you grant a use permit, grant a conditional use or an interim use permit for a gravel pit, and a bunch of neighbors appeal your decision. It goes to the county board. Interim use permit's a bad example. I'm going to switch to a conditional use permit. Conditional use permit for storage. The neighbors appeal to the county board. The county board decides to deny the conditional use permit. So the issue there is that a conditional use permit is a land right. And the only way that it can really be taken away is if you, the planning commission, they violate the conditions. That's pretty explicit. So the issue becomes is that if that were to be appealed to the county board and the board were to deny it, then the board is taking away that land right. And that could be challenged in court, and it would not probably go very well. So the thought with use permits is to just, and a lot of other counties do this too, is all appeals of your decision. The planning commission, like the Board of Adjustment for variances, is the final decision maker. They would go, anyone wants to appeal it, including the applicant, if you were to deny a permit, that would go to Court of Appeals or District Court. So it would take the county board out of that appeal process.
I don't know that it would be I mean, either one likely, I mean, I'd probably a wash, I mean, to whatever degree. I mean, if you're probably better off, I mean, being in the district court to go through their rules. If you're not gonna use an attorney, they'd probably give you a little more leeway. The Court of Appeals is a three-panel judge, three-panel judges, and pretty strict on their rules and their requirements and everything else, so,
It'd be easier to go through district court than as a,
probably.
that's how I would do it then.
Mr. Chair and Mr. Melton, for my benefit, can you give me and maybe all of us a little lessons in civics? What's Court of Appeals? What's district court? What's the difference?
Right, so district court would be here, local, one judge, a local judge who's regularly appointed by the governor, but six-year term, then they're voted on by local folks. Typically, within the criminal realm or civil realm, you know, if you file a case and you have a case here in district court, local court, then you appeal that to the Court of Appeals, which is a three-judge panel. And those judges are experienced judges in law, probably been district court judges previously, and so
So the progression would go from district to Court of Appeals.
typically. But in this case, you could, and I think that's some of the stuff that Matt and I just discussed, the idea of, there's sort of that idea, would you want it to go to the county board as a first place just because they are constituents? That's a discussion point, you know, the idea that they want to be heard both by the planning commission and their own commissioners that are elected. But on the other hand, they have appointed you to make decisions. And so that's the reason to say it's not just giving people two bites at the same apple. It's you've made your pitch. It's either granted or denied. If it's denied, it's now into a different, more official realm, or a different official, not more official, but just a different official realm where it's now a judge or a three-panel judge court that's looking at the matter. So, yeah, typically, so the progression is district court, local, three-judge panel Court of Appeals that's typically down in St. Paul, and then the Minnesota Supreme Court, which is a 9-judge panel.
Thank you.
And I think, and I did send you that case law. I don't know if you had a chance to look at it, but that was the, I think there's case law that goes both ways.
Right.
It seems like.
I think we could do it either way. It probably just makes sense to allow for it to go to the Court of Appeals. It's a trained 3-judge panel. Or I take that back. I mean, I think either one. I mean, district court is local, so that allows folks that are right here, the 3-judge panel. Typically either St. Cloud or the Twin Cities where you're usually going.
So if you lose in district court, could you go to the Court of Appeals and after that?
They would have that.
That would be the next one, and then after that would be the Supreme Court of Minnesota.
Each one has the ability to potentially deny, or, so if you made it, in the statute, you would say it's district court, they have a chance to appeal to the Court of Appeals, but the Court of Appeals could deny.
Yeah, I mean, you could be denied all the way down, but you could still.
Right.
Is there an advantage to use the Court of Appeals first? You said there are 3 judges trained. Is that, I mean, you
Right.
kind of leave out one of your options, I guess.
I think that's kind of that debate of what's the best and easiest way to kind of make it happen and give them their opportunity to be heard, give them a chance to appeal, and it would be done. I mean, I think either way. I don't really have a strong opinion one way or the other. I'm not sure which is the best way, to be honest. Like Matt said, it's kind of you've seen it both ways, so I'm not sure there's really a best way.
And I know Kristen Yeargarden just recommended the Court of Appeals because that's what she sees the majority of the time. And her, I think, her reasoning for it was it's just more timely and efficient. That's, yeah. And she said there's case law that supports that these should go to the Court of Appeals, but then there is another subset of case law that says district court is acceptable too.
And I agree with Ezra on the district court thing, strictly because it's still local.
Yeah, and if you wanted to have the step for, to go to board, then I think the recommendation is that the planning commission becomes just a recommending body to the board for use permits, and the board makes a decision.
On all of them.
And there would not have to be a public hearing at the board. It would just be making the decision to accept the planning commission recommendation or to not accept it based on the record. The record, which was basically everything, staff report, the application, comments from citizens, public hearing at the planning commission and things, and all of that.
Now, you said for use permits, is that both conditional and interim?
Yes. So personally, I think that unless the county board feels otherwise, I think that going right to either district court would be fine. Just keep it district court for variances, because it has to be use permits and amendments.
The reason I like district court is so you're not saddling the person, whoever's trying to challenge it with a big bill going down to St. Paul, hiring attorneys.
Yep.
It's more affordable if you're gonna challenge it to go through district court.
And they would in state law at all that you have to go one way or the other, only for variances.
So here's a question for you. Do all counties have a planning board like this?
Not all, most do. Sometimes the county board is,
Is the,
yeah, sometimes it's the Board of Adjustment and Planning Commission are the same. Yeah, and it is a mixed bag, I found out, in terms of, some counties have the planning commission make the final decisions on use permits. Some counties do recommendations. Becker County.
Becker County is one of those that makes.
Yep, Stearns County is an example. They do that too. So, I know our county board has very full agendas every week. And so that would just be another thing, to add to their plate. And I think that for the most part that they've been very, they trust your, judgment and decisions on these use permits, I would say. I don't want to speak for them, but that's just kind of the sense that I get.
That's where I sit, being there for 2 months, but coming from this, I trust everybody on here to make the right decision. I think since I've been on here, I think we've made 95% of the right decisions.
Okay. Well, just hearing this discussion, then maybe and spend a lot of time on appeals, but this is kind of a big thing that we want to make sure we get right. And my thought would be to just have it go to district court. Is that kind of what I'm hearing? Okay. Sounds good. So next steps for this would be to address the shoreland comments, address the attorney comments, do a final review just for formatting definitions, and that could happen. That'll probably just be an ongoing thing. And then to have the planning commission, the final public hearing, the one that we were supposed to have tonight, to recommend to the board on April 22nd. Unless you all feel like you need more time, or if you're like me and just want to feel pretty good about it and ready to make a recommendation.
Are you gonna do all 8 chapters or 9?
Yeah, and that was the intention for this meeting, because I know we did spend in December time on the first 4 chapters, and then January we did spend time on the 5 through 8, and yep. So if everyone feels good about that.
One question.
Yes.
Is the planning commission meeting in April the fourth Tuesday?
I think it's the 3rd. Do I have the date wrong? Or, let me see here. It's the 15th. My apologies. That Tuesday slipped by me. That's April Fool's Day, so it doesn't really
Understandable.
count. Yeah.
That's the first.
Yeah. Okay. Yes. No. We'll go to the 15th. All right. Well, that's all I have, Mr. Chair, unless anyone else has any additional thoughts.
Hearing none, would look for a motion to close the public hearing on the development code update.
So move.
Motion by Ezra, second by Dave. All those in favor say aye.
Aye.
Opposed, motion is carried. Now regarding the IUP,
He is online.
okay. Like to look for a motion to open the public hearing for IUP.
So moved.
Second.
Motion by Ashley, second by Sebastian. All those in favor say aye.
Aye.
Motion is carried. Public hearing is open.
So this is Ryan Bufink, request for an interim use home occupation permit. Applicant is seeking an after-the-fact interim use home occupation permit for a landscaping business at 3563 70th Street North, Linden, Minnesota, 56547, parcel ID 20.030.1503 in the part of the northeast quarter, section 30, township 140 north, range 47 west, Mullen Township. All right, so this is a request for a home occupation landscaping business. So this property is zoned agricultural, general, and resource protection, wellhead protection. The surrounding properties are zoned the same, and IUP is allowed in this zoning district if it meets the requirements and is granted an interim use permit. So it's located on the west side of CSA 11. It's about 3/4 of a mile north of CSA 18, and there are residents and 2 outbuildings on the property. The request is to continue operating a landscaping business on the property. They use the 1,400 square foot shop for storage and operating the business. They operate the landscaping, the applicant operates the landscaping division out of this location. So, and then it employs 9 employees other than the owner for a total of 10. The main kind of use here is parking for employees. They park here and take company vehicles to job sites. No customers visit the property. Hours of operation are Monday through Friday, 7 p.m. to 6 p.m., April 15th to November 15th. And then there is a snow division of this business, but that is operated in Fargo. So home occupation standards limits employees to 5 non-family. The planning commission can allow for additional employees if traffic, parking, utility impact on surrounding properties can be addressed. Looks like there is ample space for parking, approximately enough space for about 38 parking spaces. So that's more than what's currently utilized. The applicant's also using the furthest south location for the business, which is creating a buffer between the neighbors to the north. And then there's a pretty significant tree buffer with the neighbor to the south. So in resource protection, wellhead protection, outdoor storage accessory to commercial use is not permitted. So any storage associated with the business would have to occur inside a building or a structure. That doesn't include parking. You can do parking. So We have not received any public comment for this request. Also haven't received any comment from the township. From our comprehensive plan and how this request relates to our goals and objectives, we have a goal to maximize the potential of Clay County as a thriving center for agriculture, business, and recreation while maintaining and enhancing its livability. The home occupations that follow regulations of Clay County provide unique opportunities for residents to live and work in the county. They have the potential to enhance both the economy and livability of Clay County. We have a land use goal to establish a comprehensive growth management strategy that promotes orderly and efficient growth of residential, commercial, and industrial development while preserving the county's rural character. Home occupations do not necessarily fit into this strategy overall, but they provide flexible living and working arrangements. They make for more efficient use of large tracts of residential properties and should not detract from the rural character of the county, provided that the structures and use are in harmony with said rural character and the use does not create nuisance conditions. Then we have a goal to plan land uses and implement standards to minimize land use conflicts and home occupations that meet our Clay County Development Code regulations for home occupations should not contribute to land use conflicts. Any questions for me at all?
Yes, Matt, is there currently equipment outside that needs to be inside?
There could be some equipment outside, but if it's like a trailer or something like that, like something that you can drive, I don't think you can really store that inside. I think the concern more with outdoor storage in the wellhead protection zoning district, especially in an area where you have, looking at this map, that shows basically the pollution sensitivity of groundwater. It's very high here, meaning that if you were to have like a spill of some kind of a hazardous chemical or material, the travel time to get from the surface to the water table is very short, meaning that you have probably a high water table, so the aquifer is probably closer to the surface. And really, so think of like treated wood, storing like pallets, things like that. Any chemicals or anything like that, storing that outside would be discouraged or not allowed. Now, if you're parking some things that you can't, you don't keep inside, like trailers and things like that, I think that would be acceptable.
Thank you.
Mr. Chair, I have a comment on that. I've been driving by this property, I don't know, for the last 10 or 15 years, almost weekly now. It's always well kept. I mean, it's most of the time it's vehicles parked there. That's what you see. It's not a bunch of stuff out there like fuel barrels and stuff like that outside the area. Pretty well kept piece of property.
Well, and in the description of what they're doing, they don't list, spraying and as one of their things that they do at seeding and. Okay. Anybody have anything else for Matt? Okay, would the applicant care to speak? Hello, Ryan?
Good evening. Good evening.
We can hear you,
I
Ryan.
can hear you.
Yep, go ahead.
Would you like to speak regarding your permit application?
Yeah, I will throw in a few things. Yeah, we do not do any sort of chemical, weed spraying, fertilizing, anything of that nature in the business. The whole purpose of this is basically vehicle storage or trailer storage. There's, 8 trailers here and 6 vehicles, I think. That's basically it. I do keep nothing gets sold out of here. No customers visit here. Everything that I can store inside does get stored either in the shop, in the garage, or in the storage containers.
Thank you. Anybody have any questions for Ryan?
I have one question. This is Ezra Bear. How long have you been running this business outside your home there?
I bought the property a couple of years ago from my dad, and I kind of started the business out of the property. So it's been 2016 is when I started the business, August of 2016. So on and off basically from there, the last 5 years have been serious growth, if you will. So the last 5 to 8 years, basically.
Thank you. Okay, thank you, Ryan. Hearing no further comments or questions, look for a motion to, oh, sorry, yes. Is there anybody in the audience that wishes to speak for or against this? Is there anyone in the audience that wishes to speak for or against this permit application? Is there anyone in the audience that wishes to speak for or against this? Hearing none, now I look for a motion to close the public hearing. Motion by Brad,
Second.
second by Ezra. All those in favor say aye.
Aye.
Opposed? Motion is carried. Thank you, everyone. Okay.
And Mr. Chair, I do, we have drafted findings here that you can modify or change as you see fit. If you, no need to read them, because they're a little lengthy unless you feel the need to. They're just below, they're italicized on the screen, and I can close out my PowerPoint here so I can show you actually what they look like. There you go.
Okay. Well, thank you, and we will begin going through the 13. In granting an interim use, the planning commission shall consider the effect of the proposed use upon the health, safety, morals, and general welfare of occupants of surrounding lands, existing and anticipated land uses, traffic conditions, including parking facilities on adjacent streets and land, and the effect on agricultural usage and values of property, scenic views in the surrounding areas, and the effect of the proposed use on existing comprehensive plans. Use and enjoyment of other property. The interim use will not be injurious to the use and enjoyment of other property in the immediate vicinity for the purpose already permitted, and not substantially diminish or impair property values within the immediate vicinity. Development of surrounding property. The establishment of the interim use will not impede the normal and orderly development and improvement of surrounding property for uses predominant in the area. Utilities, access roads, drainage, off-street parking, and loading spaces. Adequate measures have been or will be taken to provide utilities, access roads, drainage, and off-street parking and loading spaces. Nuisance conditions. Adequate measures have been or will be taken to prevent or control offensive odors, fumes, dust, noise, vibration, water pollution, and soil erosion, so that none of these will constitute a nuisance, and to control lighted signs or other lights in such a manner that no disturbance to the neighboring properties will result. Burden on public services. The use will not create an excessive burden on parks, schools, streets, water supply, sanitary sewers, and storm sewers, and other public facilities or utilities which serve or are proposed to serve the area. Compatibility. The use will be sufficiently compatible or separated by distance or screening from adjacent agriculturally zoned or used land so that existing homes will not be depreciated in value and there will be no deterrence to the agricultural use of said land. Appearance of structure and site. Structure and site shall have an appearance that will not have an adverse effect upon adjacent residential properties. Relationship to overall needs. The use, in the opinion of the Planning Commission, reasonably related to the overall needs of the district and to the existing land use. In the case of the floodplain areas, the proof that the location is necessary for facility operation and that alternative sites are not susceptible to flooding are not available. Consistency with ordinance. The use is consistent with the purposes of this ordinance and the purposes of the zoning district in which the applicant intends to locate the proposed use. The use is not in conflict with the comprehensive plan, if any, of the township, city, or county. Traffic hazards, congestion, and floodplain areas. The use will not cause traffic hazards or congestion, and floodplain areas has access during flooding for ordinary and emergency vehicles. Existing businesses nearby will not be adversely affected because of curtailment of customer trade brought by the intrusion of noise, glare, or general unsightliness. I'm assuming the applicant is the person living, is occupying the residence on site?
That's correct.
Okay. I guess the only other concern I had, he mentioned quite a few trailers, and I get that, but we would have heard from the township if there was road restriction damage or something going on in the springtime, because he will be
He's right,
airing up here soon.
he's right on a Casa Road.
Oh,
Yep.
he's got access to a 10-ton.
It's a paved,
That's a 10-ton road.
yep.
It's a concrete one.
Oh. Okay, well, that takes care of that.
Mr. Chair, would you like me to read the conditions? I can do that, and then, with this being an interim use permit, we would have to make sure that the applicant is agreeable to those conditions.
Yes, please.
Okay, so number one, home occupation shall comply with the Clay County Development Ordinance home occupation standards. Number two, the permit would cease upon ownership change. Number three, employees shall be limited to members of the House and 10 additional non-family employees unless a plan for additional employee parking and mitigation of potential impacts are provided to the planning office. Number four, outdoor storage accessory to the commercial use is prohibited. All commercial storage must occur indoors.
Go ahead, Mr. Steichen.
I have a question, Matt and Mr. Chair. Am I remembering this incorrectly, but doesn't interim use have a specific amount of time it's allowed to be run?
Mr. Chair and Mr. Steichen, it can be either a period of time or an event that would trigger that.
I guess I'm confused.
An event being like a ownership, like if the applicant or the permit holder were to sell his property or convey his property to someone else.
I guess in the past, it's always come up on mining that it's a specific time, so that's
Yep.
what I had in my mind. Thank you.
I've got just a quick question here, or two. Is it 9 additional non-employee family members, or do they want a buffer in case they need to add?
That would be a good question for the applicant. If you would like to go beyond the 10.
Yeah, could we, I mean, we have, an additional shop in Fargo that we run 5 employees out of 2. So, you know, I guess if we could shoot high and say 15, I know I would probably never exceed that.
I think that's reasonable, I guess, to add it to 15. And then I just wanted to ask, do we want to have hours of operation? It doesn't sound like he has much of a nuisance, you know, loud noises coming from the shop or anything, but I know that we've added hours of operation, I think, on things too.
And Mr. Chair and Commissioners, I don't know what your thoughts are on that. His stated hours of operation are,
They were in the permit application.
it should be 7 a.m. to 6 p.m., I believe.
My 2 comments on Ashley's comments would be, he could go up to I mean, for people who work that aren't family members, it goes to parking spaces, correct?
Correct.
And the math shows 38, so I mean, 15 is very doable to have on that number, especially if they're just coming and going. And then when it comes to hours of operation, I mean, they are just coming and going from there. They're not working from there. They're not, I mean, they're coming there, picking up a piece of equipment and leaving. I don't know if we'd need to have an hours of operation, because if a rainstorm's coming, they got a job they're doing in Fargo. If they work till 8 o'clock because the storm's coming at 10 at night, you know, just to get it done so they're done tomorrow, but they got to shut off by 7 to be back at the shop by. So I don't, with it being on a CASA road, a heavy road, I don't know if hours of operation would be necessary, especially if it's just vehicles coming and going.
I see your point, Ezra, because they're not doing business.
Yeah.
They're not actually operating, doing business there, that's just a
Right.
parking.
And yeah, that makes sense to me. Just wanted to throw it out there. So.
Yeah, Mr. Chair, the only time when an hours of operation might come into effect is if they're doing any maintenance on any equipment or anything like that. Something to consider.
Which would be inside.
Yeah.
Because you wouldn't be changing bearings on your trailer at 10 o'clock at night in April outside.
No.
All right, I'll make a motion to approve conditions 1 through 4 with the correction from 10 employees to 15.
I'll second that.
Okay, we have a motion by Brad, a second by Ashley to approve the permit with the 4 conditions, with changing the allowed employees to 15.
Yeah, and Mr. Chair, I just confirmed too with the applicant that these conditions are acceptable.
That was my question. Make sure, Ryan.
Yeah, might want to ask Ryan that.
For the minutes, okay, Ryan?
Yep.
So we have you in the minutes. Are these 4 conditions acceptable to you?
Absolutely.
Thank you. We have a motion and a second. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? Permit is granted. Thank you, everyone. On to unfinished business. No, we need to close the hearing. No, we did that.
Yeah, we did.
We're okay.
Yeah.
Unfinished business, Matt?
Just a permit violation update. Well, maybe what I'll do is I'll just pull up kind of where we're at with permit violations overall. This is a presentation that I gave to the county board. Let's see if I can find it here. Bear with me. I just thought, oh, maybe I should show this right. I did not prepare. Thought I should just, I'll show it right now. Let's see here. It is, yeah, we need that. I will bring it to the next meeting. How's that sound?
Okay, no update. On to new business.
Yes, so, sad to say that, we're going to be losing, Brent Berg here, be stepping down on the planning commission. I just want to thank Brent for, all the expertise and thoughtfulness that you brought to our meetings. I know Brent's one of the planning commissioners who would always, send me an email or give me a call about things that he was seeing out and about in the county, and just did so the other day, and just really appreciated that. That level of participation and dedication. And so I don't know, Brett, if you have anything that you want to say at all, or?
Yeah, I just wanted to say I've enjoyed being on the board, and honestly, the only reason I'm backing down is that I've got two teenage kids, and I just was adding it up. My daughter throughout the years in 9 different sports, different teams, plus 4-H and showing cattle, and just too busy, too many interruptions. So I figured I better back down and hopefully find somebody else that could be a little bit more committed to making the meetings. So that's it.
Well, thank you, Brett. So hopefully, once things slow down for you, we'll have a spot for you back on the planning commission. So open invitation. And so with that, we have Josh Schroeder here from Barnesville. And Josh, you serve on the planning commission, correct? Yep. For 3 years now. He's been on the Barnesville City Planning Commission. I don't know if you want to say a few things and introduce yourself at all?
Sure.
And you might want to just use the mic there. Yep.
Good evening, Commissioners. I'm Joshua Schrader. I've served on the Barnesville Planning and Zoning Committee for 3 years with Brent. A couple of months ago, he mentioned he was on this commission and was potentially interested in stepping down from that. At the time, I was running for school board in Barnesville. I'm now on the board in Barnesville, so I've got the running part of my days out of the way. And when he brought it up again, I said, well, go check it out and see how it works. So just a bit about me. I graduated from NDSU in 2000. I'm a structural engineer. My wife and I moved down to Kansas for a couple of years. We moved to Barnesville in 2007 with our daughters, and we've been there ever since, so coming up on 18 years now. Like I said, I've been a structural engineer. I focus mainly on bridges. I've been doing that for 25 years. I work for KLJ currently. As far as I know, we don't have a lot of business anyway with Clay County or anything like that where there'd be conflicts. I do bridge design, I do bridge construction inspection, and I do in-service bridge inspections. So don't bring Brent's insurance side of things to that, but I am familiar with a lot of the issues that the board would be into, platting and the other issues you've talked about tonight. So I think I could be a good commissioner. I'm interested in doing it. Again, unlike Brent, I've got 2 daughters. My youngest is going to graduate this year and move to Duluth, so I am going to be an empty nester and should have time to participate in the board, and I'll do lots of listening until I get things figured out, but I appreciate the work that the boards do. I know how important it is to people, and yeah, hopefully you'll have me. So any questions you have of me?
Chair, I have one question for him. You've been on Barnesville Planning and Zoning for 3 years?
Correct.
How many meetings have you missed in 3 years?
Not too many. My bridge inspection takes me down to South Dakota in the summer and stuff, but I'm able to prioritize that. School board meetings are Monday nights. Commission meetings are Tuesday nights. Planning and zoning are also Monday nights. They are the first Monday of the month. Last year we had 4 of them. I don't expect there to be any interference with my current work obligations. I have a I can address my own schedule and work around if I know I've got a meeting coming up, so should be able to make it.
That's all I have to ask.
I'll just quickly say that I wanted to endorse Josh. I've been after him for pushing a year probably to take my spot here, so I'm glad he finally is agreeing to that. So he'll be really good.
Thanks, Brent.
Thanks, Josh.
Josh, good to have an engineer from the planning commission. Yeah.
Chair, do you want to go ahead and give the presentation?
Okay, certainly. In light of this being Brent's last meeting as he's stepping down, if you'd like to have a plaque for you, commemorate your service.
Thank you, Brett.
Okay, anybody else have any questions for Joshua or for Matt about him? Hearing none, would look for a motion to approve his nomination to the county commissioners.
So moved.
Second.
Motion made by Ashley, seconded by Sebastian. All those in favor say aye.
Aye.
Opposed? Motion is carried.
So Brent, when you come back on the planning commission, you do have to give that plaque back and then serve 9 years and then we'll give it back to you. Yeah.
Okay, next on the agenda is land use training opportunity.
Yes, so there is a land use training opportunity. This happens every spring. There's one in the spring. This is put on by the Association of Minnesota Counties, and then the Minnesota Association of County Planning and Zoning Administrators. McPizza is the acronym for that. There is also one in the fall that's put on by the Minnesota Counties Intergovernmental Trust, the insurer of most of the counties. This one would be in Staples on April 28th, and it's basically the whole day. There is lodging available if anyone want to go down the night before. Just so that is an option too. I plan on leaving probably bright and early and getting over there. I think Dave, you've expressed interest in going. Our assistant county administrator is planning on attending as well. If any of you want to check your schedules and if you can make it work, it's very, I think it's very much, would be very much worth your while. One of the focuses of this particular session is going to be on writing good findings of fact. So that's something a little different. But they talk about, there's a lot of things with noticing, 60-day rule and things like that, but also talk about conditional use permits and things like that. So if you can make it work, great. If not, I'm going to bother you in the fall about the MCIT training.
I've gone on those with Matt before. I'd highly recommend them if you haven't gone on one with him. It's very informational. So. And you get to ride down with Matt. He drives.
I do drive. And how's my driving?
Not bad. Okay. And maybe you can get him to go to Motley to get some fish too. If you're that cool.
Yes.
Are you finished on the land use? Okay, this doesn't really pertain to the planning commission, but it's one of our planning commission members. I had the opportunity to go down to St. Paul with Moorhead Fargo Chamber of Commerce. They had a huge cross-section of business, municipalities, higher education, and there's about 38 of us. It was pretty neat that we got to meet with influential lawmakers, and Commissioner Mojo and Commissioner Krabanoff from the county commissioner were there. And I can see that Commissioner Mojo has done a lot of work behind the scenes prior to us going down there because they were very familiar with what she's been working on, you know, specifically the biofuels, the aviation fuel, the psychiatric facility that they're working on, and the flood protection for Moorhead. Just a few of the things. And it's not the best year to ask for money from the state because when we're down there, we had 2 days on the Hill and then 1 day with the League of Minnesota Cities. The economic forecast came in 160 million less than it was proposed. And they knew it was going to be down. So it's a tough year to be for asking. But Commissioner Mojo has spent a lot of time, I can tell, working on these issues. And we had a chance to meet with the Governor Walz. And he is so behind, so backing the biofuels and the psychiatric facility. It's kind of neat to see that it's high on our radar. And Senator Ann Rest she spoke to us and she said that this is the most important legislation in her 40 years, the psychiatric facility, that she's ever had to deal with. So when you get her attention, that's a great starting point. And I talked to some tribal leaders, and they're all for, we're part of the county, and the county is very proactive on what they've been proposing to do here with definite costs. But the tribal leaders are so behind this as well. And I think all the tribal communities have signed on as far as the other different municipalities. So if it happens this year, who knows? But I know I'm going to talk to Commissioner Mojo when I have a chance. But I just wanted on record that they've done a fantastic job. And thanks for sending them down there, for the county commissioners sending them down. And she's a great spokesman for the county in so many ways. So it's just great to see her excitement and her dedication to making the county better.
One comment on that, Dave. She was down there today, that's why I'm here today.
Okay, well,
She was
that's
back
another,
down on Thursday.
another example of her putting in the time down there.
Yes.
Anybody else have anything? Thank you, Brent. Hearing nothing, what for motion to adjourn?
I make the motion.
Motion made by Brent. Second. Second by Brad. All those in favor say aye.
Aye.
Opposed? Meeting is adjourned. Thanks, everyone.